Good morning. Thank you for joining the press conference to discuss the Independent Resolution Panel's decision regarding the University of Louisville, case number 00843. Please note that everyone is in listen mode only, and after the chief panel member provides his remarks, we will move into the Q&A portion of the call. As members of the media, you should have received a link to both the news release and the public case decision, which contains the details of this case. These materials are also available on the IARP website, which is at iarpcc.org under referred cases. And now I will introduce Wendy Walters, NCAA Managing Director of Hearing Operations and Infractions Appeals Committees. Wendy?
Thank you, Amy. Before we begin, we want to first provide a brief overview of the Independent Accountability Resolution process. The Independent Resolution Panel is part of the NCAA's Independent Accountability Resolution process, or IARP. The IARP is responsible for reviewing select complex Division I infraction cases with the goal of increasing accountability in intercollegiate athletics by creating an alternative to the NCAA's peer review process. Once a case is accepted into the IARP, an independent resolution panel made up of 5 members and 1 alternate is appointed by the IARP's Independent Accountability Oversight Committee. The hearing panel reviews the allegations, the institutions and any involved individuals' responses, the complex case unit's reply, and conducts a hearing with the parties. Following that hearing, the Independent Resolution Panel will deliberate and determines whether violations occurred, determines the level and classification of the case, and prescribes the appropriate penalties. Decisions issued by the Independent Resolution Panel are final and are not subject to appeal. The Independent Resolution Panel members for this case were David Bink, Senior Vice President, General Counsel, and Assistant Secretary of a retail company, international and domestic arbiter, and the Chief Panel Member for the hearing panel. Jody Balsam, an Associate Professor of Law at a non-NCAA institution. Jeffrey Benz, an international and domestic arbiter and mediator. Nona Lee, founder and CEO of a diversity, equity, and inclusion consulting firm and former chief legal counsel for a professional sports team. And Tracy Porter, CEO of a business consulting firm and a former collegiate and professional athlete. Chief Panel Member Bink will now discuss the findings, conclusions, and decisions of the Independent Resolution Panel. Following opening comments, he will take questions. Please note that the hearing panel's decision stands on its own merits and again is not subject to appeal. Mr. Bink.
Thank you, Ms. Walters. Additionally, I'd like to take a second to thank my fellow hearing panel members for their commitment and effort in working together to resolve this case. Further, I also would like to thank the hearing operations staff and contractors for their help and support in the process. The Independent Resolution Panel's decision details the findings and penalties in this case. You should have access to the decision itself, but I will provide a brief overview and then answer any questions you may have. My comments today are designed to address your questions. However, the report stands on its own merit. The case involved allegations related to 2 separate coaching staff tenures at the University of Louisville. The case originally arose from the 2018 criminal indictment of 4 individuals related to an apparel company in the U.S. District Court for the Southern District of New York. The apparel company was the exclusive supplier of designated products to Louisville. The alleged violations occurred from, the alleged violations during former head coach number 1's tenure related to the recruitment of prospective student athlete number 1 and prospective student athlete number 2, and involved former assistant coach number 1 and his former associate head coach. During former head coach number 1's tenure, the former assistant coach number 1 participated in a meeting that was part of an FBI surveillance operation that led in part to the 2018 SDNY indictment that I referenced a moment ago. On July 27, 2017, former assistant coach number 1 met with the business manager and the trainer for prospective athlete number 2, an undercover FBI agent and financial advisor number 1 in a hotel room in Las Vegas. During the meeting, there was discussion of funneling money to the family of prospective student athlete number 2 with the intent of influencing that prospective student athlete to enroll at Louisville. There was an envelope on the table believed to contain several $1,000s in cash. The hearing panel found that former assistant head coach number 1 was involved in the arrangement of a recruiting inducement and failed to report information related to a potential violation to the institution. This violated NCAA principles of ethical conduct. The panel determined that this was a level 1 violation. For the former associate head coach, the hearing panel found a level 3 violation occurred when he had impermissible in-person off-campus recruiting contact with prospective student athlete number 1 at an NCAA certified event in Las Vegas. Further, we found that the associate head coach furnished false and misleading information to the NCAA enforcement staff regarding the occurrence and his participation in that contact. The former associate head coach's failure to cooperate is in violation of NCAA principles of ethical conduct. The panel determined that this failure was a post-separation level 1 violation. The hearing panel also found several level 3 violations that occurred during former head coach number 1's tenure. The panel determined that these level 3 violations, determined these to be level 3 violations because they were inadvertent and provided no more than minimum recruiting or competitive advantage. These level 3 violations were, as mentioned previously, the former associate head coach participated in an impermissible in-person off-campus recruiting contact with prospective student athlete number 1 between July 19 and July 25, 2016. The former assistant coach and associate head coach provided impermissible transportation benefits. The former associate head coach provided these benefits to the business manager for prospective student athlete number 1 during an unofficial visit to the institution, while the former assistant coach provided this benefit to the trainer for prospective student athlete number 2 during an unofficial visit. Then, during former head coach number 2's tenure, the hearing panel determined there were violations related to recruiting materials and the participation of managers and non-coaching staff members in on-court practice activities. The panel determined these violations to only be level 3 violations because they provided no more than a minimal competitive or recruiting advantage. The following level 3 violations occurred during former head coach number 2's tenure. Managers and non-coaching staff members of the Louisville men's basketball program were found to have actively and consistently participated in impermissible on-court activities, included but not limited to on-court competitive situations. Members of Louisville's men's basketball staff participated in impermissible recruiting activities by producing and showing personalized recruiting videos to men's basketball prospective student athletes. The panel did not find any violations whatsoever applicable to former head coach number 1 or former head coach number 2, and the panel views this decision as exonerating both former head coaches. Louisville did not self-impose penalties or take additional corrective actions regarding these allegations. The panel reviewed the full case record and determined the case is classified as a level 1 mitigated for the University of Louisville, a level 1 standard for the former assistant coach number 1, and level 1 standard for the former associate head coach. Before I address the penalties, I wanted to remind you that most of the violations in this case were recruiting violations, that were the result of decisions and actions within the Louisville men's basketball program, and the hearing panel prescribed penalties accordingly. The panel was intentional in not prescribing penalties that would have a negative impact on the current student athletes. The penalties found for the University of Louisville, which are detailed in the decision and the news release, and were all well within the prescribed penalty matrix approved by the membership, include a $5,000 fine, 2-week ban on unofficial visits during the 2022 to 2023 academic year, additional 2-week ban on recruiting communications during the 2022 to 2023 academic year, a 7-day reduction in the number of recruiting person days for the 2022 to 2023 academic year, and 2 years of probation starting November 3, 2022 through November 2, 2024. The panel prescribed one penalty for the former assistant coach number 1. That penalty is a 2-year show cause order. The panel also prescribed for the former associate head coach a 2-year show cause order precluding his attendance and evaluations at any permissible live activity events in the spring and summer evaluation periods during the 2-year show cause period. Additional penalties include public reprimand and censure. The institution's probation will be publicized on the NCAA's website, in appropriate publications, and in appropriate NCAA championship game programs. Non-coaching men's basketball staff members may not participate in any on-court activities for 10 basketball practices during the 2022-2023 season. The men's basketball program also may not show personalized recruiting videos to prospective student athletes during the remainder of the 2022-2023 recruiting calendar. This concludes my remarks. I'm now happy to answer any questions. Amy, please tell everyone how they can ask questions.
Thank you, Chief Panel Member Bank. We will now take questions, and Chief Panel Member Bank will answer questions specifically related to this case decision. And Derek Crawford, NCAA Vice President of Hearing Operations, will answer any questions related to the independent accountability resolution process. If you're a member of the news media, please use the raise hand function at the bottom of your screen to indicate that you have a question. I will recognize you by name, and at that time, please unmute yourself and ask your question. But please remember to place yourself back on mute after you ask your question. We will start with Michael DeCourcy. Michael, please unmute yourself and ask your question.
There we go. All right. I apologize for the delay. My question simply involves the fact that at the time these violations, these alleged violations were alleged to have occurred, the University of Louisville had recently been placed on a probation for a prior case. It doesn't appear that the penalties reflect that in any way. Was that a part of the deliberation and the punishment at all?
Mr. DeCourcy, I think I would point you to the decision. I don't have the exact page, but approximately page 82, 83, somewhere in that range. There's a discussion about that. The prior case was considered an aggravating factor, so it was considered and it was added in.
Tyler Griever, please unmute yourself and ask your question.
Hi, can you guys hear me?
Yes.
Hi, David. I was wondering, there's been quite a long timeline in evaluating this case, and a lot has changed in the landscape of college athletics. Did that affect this decision in any way, that changing landscape at all?
Yeah, I would say that the panel was charged with applying the rules that were in effect at the time of the violations. That's what the panel did. Any changes over the years and bylaws were not considered by the board.
Okay. Pat 40, you may unmute yourself and ask your question. Tyler, please mute yourself again, please.
Yes, Mr. Bank, my question is, the NCAA is moving towards a strict liability standard for head coaches in terms of responsibility for violations within their programs. That starts roughly 2 months from now. Was the fact that that is what the wishes of the membership is going to be in any way considered in adjudicating this case with the head coaches that were involved?
You know, in general, an institution is held accountable for the violations of its staff. Varying levels of culpability is taken into consideration, whether the case is classified as aggravated, standard, or mitigated. And in this case, the case was found to be mitigated. But like I said to the prior question, the panel was charged with applying the applicable legislation agreed to by the membership. That's what was applied in this case. If there is a change in that tradition of combining individual and institutional accountability, that's beyond the scope of our panel.
Thank you. Tim Sullivan, you may unmute yourself and ask your question.
Thank you. I'm curious about the decision that the panel reached involving Adidas as a representative of the university's athletic interests. You seem to reject a spot or a position that the complex case unit was fairly insistent about. Do you see this as writing new legislation, or is it a matter of interpretation?
The panel definitely did not see itself as writing new legislation or attempting to rewrite existing litigation. It's merely an interpretation. In this case, there was insufficient, credible, and persuasive information that was presented to us to suggest that their promotion of the institution athletics department was the motivation. It was our interpretation that it was merely their own brand promotion. On top of that, you know, the institution never requested any assistance with recruiting, and in our opinion, had no knowledge of any assistance that the athletic or apparel company provided.
Thank you.
Brett Dawson, please unmute yourself and ask your question.
Yeah, David, you mentioned that the penalties are impactful mostly on recruiting because these were recruiting violations, and this seems to be in keeping with a recent trend of not penalizing current student athletes for transgressions that happened in the past. Was that something this panel reached a conclusion to do, or is that part of a larger sort of NCAA movement?
Well, I can only comment on this specific case. And yes, that was a consideration in this case, as I mentioned in my opening remarks.
Mike Vernon, you may unmute yourself and ask your question, please.
Hi, yeah, I was wondering, you just said that it was your opinion that the institution had no knowledge of this, and it brings me back to the original criminal case that argued that Louisville and the other schools involved generally were victims and unaware of what was happening. There's been a lot of skepticism around this claim and a lot of skepticism published around the claim. I was wondering if you could speak to that a little bit more around the institution having no knowledge and what you've found there.
Well, I can't comment on, you know, opinions that consider things that are outside the record. We considered 3,000 files, hundreds of thousands of documents, and there was simply insufficient, and I would say the panel found it grossly underwhelming information that was presented to us to indicate that there was knowledge that this was taking place.
And to be clear, that's knowledge from Louisville or the head coaching staff generally, right?
Correct.
Thank you.
Gary Graves, you may unmute yourself and ask your question.
Good morning. I guess, what is your timeline for finishing the work of the IARP's timeline for finishing work, and how many cases are pending?
Derek?
Could you hear me?
Yes. Yes, thank you, Gary. Pardon me while I unmuted. So this is the third decision that has been released. Previously, NC State, Memphis, and now Louisville. There are 3 other cases that are pending before the IARP process, and those are moving along, I think, at a pretty decent pace. As I indicated in previous comments, we expect to have all of the cases completed by hopefully late spring, early summer of 2023. So that's the best information I can give you about what remains in the timeline.
Tyler Griever, please unmute yourself and ask your question.
Yes, hi, David. Once again, just bringing up that timeline. I know the university itself did not self-impose penalties or sanctions in this case, but many here would consider the length of time that this took a punishment in itself. Is that taken into consideration by the panel, that the university has basically gone through this for enough time and basically lessens the penalties that you all issued?
I would say the timeline challenges, well recognized, were not a consideration. The panel went through the determination, decided the level, decided that it was mitigated, and assessed penalties that were within the range as recommended by the membership. So that factor was not considered by us.
Mike Vernon, please unmute yourself and ask your question.
Yeah, I'm curious as well about NCAA presence during the hearings. Was there a large presence from the governing body through the hearings or discussions?
I may let Derek answer that. I'm not sure how to quantify, since I'm talking about one case here, whether it was large or not.
David, we attend all hearings. As the vice president of hearing operations, I'm at every hearing. It's a part of my job responsibilities, along with my colleague, Wendy Walters, who is the managing director, and other members of the NCAA hearing operations staff. I think NCAA enforcement also attends the hearing as a silent observer. So that's general that we always do. It's nothing unusual about any hearing. That's normal staff participation to support the work of the hearing panels.
How many, is there an estimate of how many NCAA staff members in total might have been there between enforcement and in your group, Mr. Crawford? Are we talking 10, 20, 30 more?
I don't know that the number is necessarily that critical. Again, as I stated, we always attend these hearings as a part of our duties and responsibilities as members of the NCAA staff that oversees this process. And that's what we do in every hearing, unremarkable about Louisville or any other hearing in that regard.
Well, yeah, I guess I asked because most hearings aren't or historically haven't been through an independent panel. So that's why I was curious. And I think it's important to note or take into account NCAA presence at an independent hearing. So that's some context.
Thank you. Eric Crawford, please unmute yourself and you may ask your question.
Yes, at one point in the case report here, the NCAA, it appears, is arguing that former head coach number one did not promote an atmosphere of compliance because he was too strict on compliance, and that the panel found that not a persuasive argument. I just wonder about the factors that the panel used in terms of determining that the former head coach had in fact promoted an atmosphere of compliance.
Eric, I think if rather than spend time on the call going through that, I would point you to page 53. There's a pretty good section there where the panel lists out all the steps that were being taken by the former head coach number one to promote such an atmosphere. Again, we did not find it persuasive that there was such a thing as being too persistent. And I would remind everybody that I think the panel felt that the institution and the coach were hypersensitive to compliance issues coming right on the heels of the prior case. So we did not find it persuasive that they were being too focused on compliance.
Billy Witz, please unmute yourself and ask your question.
Hi, David. I wanted to ask you about just the connection between Adidas and Louisville, and Merle Code, one of the Adidas employees who was involved in this, has testified or said that he was told by his higher ups that Rick wants our help. And to get it done. And I'm just wondering if there was, I guess if that, you seem to, I'm just wondering whether the committee thought that those sorts of, sentiments and testimony had been considered credible. And if there was any thought given to why would Adidas give Brian Bowen's family $100,000 if in front of, in a meeting, or agreed to those things with a coach from Louisville present, if Louisville wasn't interested in participating in this arrangement.
Well, there's a couple things a couple questions embedded in there. Initially, I'm not aware and don't recall any testimony from Mr. Merrill Code. If you look at pages 8 and 9 of the decision, you'll see a discussion about the book he authored, which, and I don't want to read it to you, but it essentially says that he didn't have authority to make this on his own. He spoke to his bosses. They ran it up the chain at Adidas. Someone he believes spoke to somebody somewhere, and it came back down that Rick wants our help, something like that. The panel found it unhelpful, I guess I would say, that this language was in a book about this situation. It was multiple levels of hearsay. If you read it closely, there's not even confirmation that anybody spoke to Coach Pitino. It just came back down that he wanted our help. So we found that completely unpersuasive and unhelpful to the case. As it relates to whether or not the athletic apparel company, why they would do that, I think you can tell from the decision that it was our interpretation that they were primarily motivated by brand promotion, and they were trying to take steps to promote their brand.
Thank you. Matthew McGavick, please unmute yourself and ask your question.
David, I'm curious, you mentioned that you were ruled that Adidas was operating with their own brand promotion in mind. Was there a single determining factor in reaching this ruling, or was it the overall body of work presented?
I would say it was the overall body of work, but I would also emphasize that the panel can only consider the information that was presented to us. And the information that was presented to us was not deemed by the panel to provide any additional color or indication to the contrary. Everything we saw indicated it was more brand promotion and not to promote the institution.
Pat 40, please unmute yourself and ask your question.
Yes, Mr. Bink, I found I believe the section regarding Louisville's previous history of level 1, level 2 major violations by the institution, and Louisville and the complex case unit agreed that aggravating factor applies to Louisville. Yet the case was considered level 1 mitigating, I believe. Can you explain the discrepancy there?
Well, I don't believe it's a discrepancy. It's not I believe that's the only aggravating factor that we found, and there were several mitigating factors. It was not a 1-for-1 weighing of aggravators versus mitigators. It was a weighing of the entire case record. And that's what we did. And based on the entire record that was presented to us, we believe that it was a mitigated case.
Matt Norlander, please unmute yourself and ask your question.
I just wanted to briefly ask about the punishment handed down by former associate head coach, which is Kenny Johnson, who's now at Rhode Island. He has been given a 2-year show cause, but it apparently only pertains to him not being able to recruit in the live period in April and July for the next 2 years. But he is, as my understanding, he is actually able to resume all other coaching duties. Was there any precedent to that kind of punishment that you look back and saw in previous cases across the history of the NCAA? And whether there was or wasn't, how did the board here come to that specific kind of punishment where they're basically saying you can keep your job except for 2 weeks in April and 3 weeks in July for the next 2 years? It just seems a bit sporadic in how you handed down that punishment.
Certainly. So, yeah, the underlying allegations arose out of, I guess, what is common parlance, a bump at a function or event in Las Vegas. It was a recruiting violation. The level 1 piece of the former associate head coach found that he was untruthful when initially questioned about this by the enforcement staff. Subsequent thereto, he was much more forthcoming and open about what took place. So it was, in our opinion, that the best penalty would be to restrict his ability to recruit in similar functions during the period.
Okay, is it safe to assume that had he not been more compliant, then perhaps his show cause would have reflected that of the former Louisville assistant who just had a full-on 2-year show cause then?
I don't know that I'm prepared to answer on behalf of the whole panel on that.
Okay, thanks, David.
Do we have any additional questions from members of the news media? Gary Graves, please unmute yourself and ask your question.
Yeah, as a follow-up, I guess, to what the committee has done, I guess, David, if do you have an opinion on the effectiveness of this panel and how it is examined all of these cases, particularly with Louisville? Do you feel like it is made an effective assessment of everything that's happened in this?
I can only speak to this case again, and I would say that the panel in this case was diligent. I think everyone would be surprised at the hundreds, if not thousands of hours that has been spent on this case, the hundreds of thousands of documents, the hearing. The panel worked very hard on it. We're an independent panel, so we didn't bring any biases to the hearing. I think we brought a level of professionalism to it. And the panel, speaking strictly for the panel, thinks it was very effective.
Are there any other questions from members of the news media? Billy Witz, please unmute yourself and ask your question.
Yeah, David, I was just wondering how many people on the committee had any sort of background in college basketball or I guess more pertinently, the world of college basketball recruiting. I mean, or was it, was a lot of this just, sort of needing to, educate yourselves on this world?
I don't know that I can answer as to the exact bios of everybody on the panel and what their histories were and their experiences relates to college basketball world. But, as in almost all disputes, there's a responsibility of the panel members to get up to speed and educate. The IARP provided training and an education to us regularly on these issues. And then we rely on the parties to present their cases to us. And we are educated through that process also from hearing each side present their case.
Tyler Griever, maybe you can unmute yourself and ask your question.
Yes, I'd like to direct this toward Derek if he's still on the call. Since David himself can only speak to this particular case, Derek, looking at this case as an example in the timeline of cases that are yet to be adjudicated, does the changing landscape of the NCAA, the timeline involved here and how long this took, set a precedent for how some of those cases might be determined in the future?
Tyler, I don't think so, because as David has indicated, and I think as we have indicated in previous press conferences, each case really is decided on its own merits. There are certain similarities and commonalities in many of these cases, but they're also very, very dissimilar, and the facts are different, and so are the violations that are alleged. So each of the hearing panels does its work efficiently and effectively in looking at these cases, and they really make their decisions based on the particular facts of each case. We also don't get into consideration, necessarily what's happening in the future. It's what is the legislation, what are the penalties that the membership has prescribed at the time that the violation occurred. So that's really how these matters take place, whether it's in this independent process or in the peer review process before the Committee on Infractions.
Drew Diener, if you would like to unmute yourself, you may ask your question.
There we go. Can you hear me now?
Yes.
I was just curious. A lot of times when we hear NCAA decisions come down, we don't know necessarily what the standard is of, in the courtroom, it's beyond a reasonable doubt, but we're never, sometimes unclear in NCAA cases. Was the standard of whether events occurred by whatever coach, ever player, more along the lines of a legal standard of beyond a reasonable doubt, or what was the standard to determine whether people did or didn't do things?
So we did not apply beyond a reasonable doubt or typical legal standards as you're probably familiar with. I would say that the panel was not persuaded by the balance of the testimony and the evidence that was presented to us.
Do we have any other questions from the news media regarding this infractions case? If there are any further follow-up questions, please feel free to email me at Borshoff, BORSHOFF, at IARPCC.org, and I will obtain a response for you. Seeing no further questions, we will conclude